and welcome to Bharata First. I'm Frank Rausan Pereira. This is Frank Talk, and here we are today to talk about yet another episode in our series on the Insolvency and Bankruptcy Code. We are trying to decipher and make the complex subject far more simpler for you so that it is easily consumable to the masses. Today, we're going to talk about IBC 2.0, the next generation in IBC. What that means is we're going to look ahead, understand, of course, how the IBC led to what it is today, and what is it that we can expect, say, over the next 1 decade. And to talk about this very important issue, I have a stellar guest list here with me on the program. Let me introduce today's guest of honor, Anita Shah Akella, Joint Secretary in the Ministry of Corporate Affairs and ex-officio member of the Insolvency and Bankruptcy Board of India. Welcome and thank you so much for being here. Also with us on the program is Sumant, Batra, insolvency lawyer and one of the foremost advocates really as far as insolvency matters are concerned. And also with us is CA Akhil Ahuja, founder of Mavent Restructuring, and who is a key person as far as insolvency matters are concerned. So, Anita ji, let me start the program with you first. Let's try and understand, because you've been so closely working with the amendment bill, that came up in 2025 in August. Of course, you've been with the IBBI now for 3 years. Take us through the process, how you went ahead with, what is the process of policy making really, first and foremost, and what went into bringing about this amendment bill?
Hi, thank you so much for having me on this show. To start with, when I joined, in fact, in March, somewhere around May 22, the bill was already in process. So we usually have a process of having a committee. There is an insolvency law committee which has a number of experts from various fields, especially insolvency lawyers and policymakers from RBI, from the different ministries of the government, from the financial services, and the bankers especially. So this kind of a committee actually deliberates on a lot of issues that keep coming up from time to time during implementation, or there is some judgment which is probably not really followed the intent of the law, or there is some judgment which is throwing light on the way we have to go forward. So these kind of things are usually discussed, and then we also look at the international best practices that are coming up. So how we work towards these and how we can really put them in action. So by the time I'd come in, we already had insolvency law committee report on the cross-border insolvency, on the group insolvency. So we were in the process of fashioning an amendment bill towards inclusion of these two subjects. And there were certain judgments, which rainbow paper judgment, the Vidarbha judgment, which had kind of made us relook at what was the intent and what ultimately translated into action. And also the judicial delays that were happening at the NCLT level, delays at admission, delays at every stage. So what was the reason? Why was it like a business as usual? And time, as you would appreciate, is the essence of insolvency. It is very, very important that we maintain that integrity of time, because as you delay the process, the value of the corporate debtor falls. So these were the kind of things that were in the mind, and the bill was a little way smaller than what it is today. Then the Honorable Prime Minister so desired that this being a law which is very close to the heart of the Honorable Prime Minister, he said, please have a look at it, make it work. And our intention is that it should be giving value to the company, because it's important. Not only recovery, it's not a recovery mechanism. It's not a mechanism for you to really see the metric, so much of recovery has been done, but more how many companies have you put back into the economy, how much of employment you've saved. So this being the metric, he said, please have a discussion with all the holders across the spectrum, and then you come out with a holistic amendment bill. So we had a colloquium somewhere in November 22 based on IBBI discussion base papers that they had made on various issues. There was a lot of deliberation, and then of that deliberation came out the discussion paper of MCA, which was floated somewhere around Feb of 23. And based on that, we got about 1800 plus comments, some saying agreeing, some not agreeing, some bringing across a lot of divergent views. So again, the process of reform or process of amendment is a very consultative process. So we had to have consultation with various ministries, with various stakeholders. IBBI had various roundtables. We had various one-to-one discussions, not exactly roundtable, but we did participate. And then we got in a lot of inputs from various people by way of mail, by way of letters. So all these were examined along with the continuous flow of judgments, Supreme Court judgments, High Court judgments, which were coming in IBC. So we had a holistic look at this, and based on that, after a lot of discussion, taking in a lot of things, I mean, it almost took us 3 years to fashion the bill the way it has come out today.
Wonderful, wonderful. And thank you for so beautifully taking us through the process itself. So now we understand and we know what really goes into making a bill, what really goes into policy formulation. It's not something that is very easy. It is a complex matter, and there's a lot of consultation that goes into coming up with this kind of information and policy formulation as well. Asman Batra, let me bring you into the picture now. Anita Shah Akella spoke about judgment, spoke about the court, etc., and how that has been a crucial aspect really as far as the IBC is concerned. So talking about the court, let's start with the Supreme Court, of course. The Supreme Court has just, so recently come up with the latest really as far as IBC is concerned, and said has called for an overhaul of the IBC with regards to a matter that it was hearing about home buyers. So tell us something about that, and what shape do you see taking now that the Supreme Court has said that we need an overhaul?
Well, first of all, thank you so much, Frank, for having me again on your show. It's my third, and it's always a pleasure to come and talk to you. And of course, when it is in such esteemed company. Just to sort of correct you, I mean, the judgment that has been delivered by the Honorable Supreme Court on Friday, Mansi Brar Fernandez case, is not really suggesting an overhaul of the IBC. It suggests three things. It focuses on the real estate cases in insolvency and expresses concerns that the NCLT has such large number of cases, and therefore we need to find a solution for their quick resolution. And to that extent, they have suggested that a committee be constituted comprising of various stakeholders, which they have suggested also in the judgment, while acknowledging that it's a public domain. Public policy is the domain of the government, but at the same point of time, they might just want to sort of consider these various suggestions that has come from the Honorable Supreme Court. But the intent is to sort of emphasize on quick resolution of the real estate cases in insolvency, so that the large number of home buyers who invest their life savings in insolvency cases don't have to wait for long and struggle to get their homes back. It is with that intent they have sort of asked that if a separate set of regulations can be formulated to provide a kind of a special approach to resolution of insolvency of real estate cases. We'll have to see how that pans out, because what it suggests is a sectoral approach to insolvency, which is a bit of a unique thing. I mean, we've had some changes in the cases where you have airlines or mining where certain clarifications were made, but we don't really have separate regulations for any particular sector in economy. So one will have to delicately look at this approach. The second thing they suggest is that, which is very important, I suggest, and that's something on the radar of the government, I believe, and part of it has already come in the bill on which was tabled in the Parliament on 12th August, is pre-insolvency. But they suggest, although of course not very elaborately, but in a couple of paragraphs, they do suggest that there should be a process where red flags, although specific to real estate, can be identified at very early stage before it sort of reaches a stage of distress, and pre-insolvency mediation can be introduced so that a lot of issues can be resolved by way of alternate dispute resolution without people having to litigate. And that also is something which is in the radar of the government. I mean, we know that there's an expert committee which has submitted a report on mediation, and I think that's also in the pipeline. The third thing that they do is they express concern on the infrastructure of NCLT, and they have recommended that the vacancies be filled in NCLT and clerk on a war-fitting basis is the expression used in the judgment, and also improve on the infrastructure. So these are the three things. I won't recall that they have mentioned the overhaul of the act, because I think IBC we all recognize is functioning very well, except the concerns for some delays and implementational challenges, which by and large would get addressed once the 12th August, the bill that is tabled in the Parliament gets approved by the Parliament and becomes the law. And of course, besides that, we've already sort of introduced three major policy reforms, which are futuristic policy reforms, which people call as the next gen reforms. That's why probably you call it as IBC 2.0, because it sort of fills a lot of policy gaps. So that way, it's not really that. But at the same point, anything that comes from the Honorable Supreme Court obviously has to be taken
seriously,
with a great amount of attention. And I'm sure they've given 3 months to formulate a committee, so a lot of deliberation will go into it.
Absolutely. Thank you for pointing out exactly what the Supreme Court has said, and brought into focus as to what we need to really do going forward. Talking about going forward, Akhil, Ahuja, let me bring you into the picture as well. Let's first understand the role of an IP really as far as the IBC is concerned, and with the amendment bill and the proposed changes, how is the role likely to change, and what do you as an IP need to prepare for?
Sure. First of all, thanks to inviting me for this deliberation. So if you see, the IBC 2016 gives us a framework, and this IBC 2.0 is a direction towards the speed and much more accountability towards the stakeholders. Specifically talking from the point of view from the insolvency professional, the IBC 2.0 making it more accountable for the professionals, either in terms of the speedy resolutions or in terms of making it more accountable to the avoidance applications. And going forward, there is also need to have a digital platform to be used into the insolvency framework to meet these expectations from the IBC 2.0. So these are the quick comments on your question. Yeah.
Absolutely. Now, as just quickly another follow-up really as far as where we are right now, and what it means, really going forward. So when we look ahead, what are the key areas, key aspects that we need to focus on? What are the key aspects do you see that are likely to change, and how are things going to change?
This is just another beginning with a lot of groundwork needs to be done. The law is there. It's upon all the stakeholders and specifically the regulator, Insolvency Board, to give an execution muscle. From the perspective of the insolvency professional, if you see, there is a more accountability, more risk, and definitely there is a requirement to have a personal liability insurance in the market, for which the market is still not there in India. So through this medium also, I will request to have that market place where the professional indemnity insurance can be brought into the picture at a reasonable premiums, so that the professional can come forward and take that risk also that can meet the expectations of the regulator and the judiciary also. So that's the one piece. The second one, if you see, due to this change, the look back period for the avoidance transaction has been increased, which make the insolvency profession more accountable first. Secondly, in case of any misjudgment, in case of the non-reporting of any avoidance transaction, the adjudicating authority has in power to start, or at least intimate to the insolvency board to start disciplinary proceedings, which again make the process risky for the insolvency professional. And as I already mentioned, the time is there to have much more digitalization of the entire system. If you see the platform that we have, one is an MCA, the another is the NCLT, the another is the IBBI, then other is the creditors. They are, in case of the real estate, they are the long list of the home buyers, and then they are the institutional lenders also. All these are having a separate dashboard to look into the process, what is being going on. My recommendation will also be that in the times to come, there was a single interface platform wherein the entire judicial process, entire complex compliance process, and whatever the process in terms of the insolvency resolution or the liquidation can be available to all the stakeholders with a single click. So that if can be managed in a long run, that could be make the process very efficient and make it more transparent also.
Absolutely. Absolutely. Okay, since we are here and since we're talking about technology, we're talking about digitization, we're also talking about IBC 2.0 and the way forward and how, we're going to ensure that we have a foolproof system, so to speak. So, Anita, Shah, Akella, let me come back to you now. Let me also understand from you, how do we further enhance the insolvency process? That is one. And secondly, the role of technology in all of this going forward, because we've seen the introduction of AI and digital technology in almost every sphere of life. So how do you look at that?
So, in the budget last year, the Honorable Finance Minister had announced the integrated platform for insolvency ecosystem, which which is supposed to be like a federated structure, a federated architecture where you've got the e-code for the NCLT and CLAT. IBBI has their own system. The information utility has their own system. MCA 21 is the repository of all the details of the company. Then the banks have their own system, and so also the case management system of all these insolvency professionals is in different platforms. Some of them probably use it on paper, some of them use Excel sheets, some of them have actually bought some software to be doing this. NESL also had a software which would help in this case management. So our plan has been that these 4 5 pillars, we put them on a federated architecture in a drop down and pull up mode, in the sense that only the data which is required will be pushed down or pulled up, so that there's no duplication of data, like the compliances that the IPs have to make with the IBBI or filing before the court, etc. All these things would be taken care on one platform. So for each corporate debtor and each insolvency professional, the entire process will go through on this platform. That being said, that is under development now. We are almost we are ready with the skeleton and all that. We're just looking for a vendor. Once the vendor comes on board, and then we should be able to start that off very quickly. And second thing, what we're doing is, insofar as the NCLT is concerned, we are moving on to the e-codes 2.0 system, which is a higher version of the existing e-code. This has AI, ML, that is machine learning is also there, and also probably some template based judgments. Template based judgments also can come out, in the sense like for a resolution plan, what needs to be seen is very template based. So it's not necessary that you go into great details more than what is important. So those kind of things we hope will hasten the processes. Then the other thing that we are looking at is the compliances that the IPs have to give, and also when they have to compliances as per the Companies Act that need to be done by the IP. Currently, it is a little haphazard, not too well this thing. So with this will also become pretty smooth. IBBI is also moving towards a platform which is going to enable a better integration with IPI. IPI is the name that we've given to this integrated platform for insolvency ecosystem. It's a part of a huge pie, so it's the IPI. So that's the way we've given it a coinage. We hope that we should have it up and running sometime mid of next year. That will be IPI 1.0. 2.0, the way we envisage is that it should come up with a once you fill in all the IM details, all the details, you should come up with an ideal resolution plan, which should come for it. I mean, AI could give you this, and then probably it's easier to bid. And valuation, claim collection, all these things should happen in a way better manner, is what we are expecting. Even currently, we are going to have a claim collection module. The e-auction module would be there. Now, for instance, IBBI has used the BankNet platform of the PSB Alliance to do the auctions of the liquidation. They are shortly planning to move in for the resolution as well. So these kind of technological innovations bring about a lot of transparency in the system. What we are looking from IPI aspect is that we should be able to monitor the timeliness. There should be red flags, and we also propose to have an app where the IP or the lawyer or somebody can get the details of what is required if their case is coming up, or some COC voting was to be held, say it to be held tomorrow, so you have an alert. So maybe we'll be able to control the timeliness of the system as well. Then the other thing we're looking at is policy intervention based on where things are going wrong. Maybe we can intervene, get a better policy either through IBBI or through the rules, or if required through an amendment, because we'll have a lot of data available for us to see which sector is having an issue, which sector maybe policy intervention is required, etc.
Absolutely. Absolutely. Thank you. I think that's a great way to go forward, and a great idea that we have as to what we need to achieve and what we want to achieve. And good to know that there are so many things in the pipeline and already underway, really, as far as the entire process is concerned. Sumant, Batra, coming back to you now, let's also talk about a couple of aspects that were raised during the course of the discussion. One is, of course, template-based judgments. How far do you see that working? How easy or difficult is it, really, as far as matters are concerned? That is one. Secondly, we were talking about judgments, we were talking about courts passing orders, etc. So, anything to look back on as far as judgments are concerned, some landmark judgments, important judgments that are going to pave the way as far as the IBC is concerned as a whole? And yeah, these two aspects, really, if we can take them up.
Oh, well, I mean, I think we've been making extensive use of technologies any which ways, are way ahead of many jurisdictions around the world when it comes to use of technology. But I think artificial intelligence is something which still needs to be tested in the judiciary. There are some concerns around it, but as Anita rightly mentioned, that there are certain low-hanging fruits where certain orders which are necessarily based on the templates can be done. What the Supreme Court also has expressed is that you can use the artificial intelligence to the extent of compiling all the factual background and everything, which is what most of the time the research associates do. But the concluding part of the judgment, the opinion, has to be expressed by the judge himself. And I think whether it's the resolution plan or various other orders, including the orders of admission, a substantial part of the writing can actually be done by the artificial intelligence. It's the last 4-5 paragraphs where you need to just analyze what has been done. Unless, of course, there is a judgment which involves the various questions of laws that have been raised, then you need to articulate almost every aspect of the judge's opinion under each question to answer it. It can really be used very extensively, but I also do hope that IPI is used for the registry system's efficiency as well, because sometimes the delays also occur at the level of registry where the listing of the matters get delayed. Some of the times when your file replies or rejoinders, they don't come on record because of the various glitches, and that also delays, because most of the time adjustments also happen because of this reason, that a particular document is not reached on the DMRS, whatever that platform is called, and I'm sure that the advanced technology will help improve that aspect as well. Now, to answer your second part of your question, whenever there has been a constitutional challenge to the IBC's provisions, the Supreme Court has delivered its judgment with great amount of speed. We've seen in the past that where, look at the National Company Law Tribunal's challenge, the constitutional challenge, way back, 2 decades back. It took 10 years for the Supreme Court to resolve that. But here, every constitutional challenge to any provision of the IBC was delivered in less than 3 to 4 months. And it's been remarkable. But at the same point of time, certain judgments from the past perhaps need a bit of a relook because they may not really complement the dynamics of the IBC and also many of the new other economic laws that have been framed recently in the last 2 decades or so. Uh, you know, India has matured as a free market economy very rapidly over the last 20 years. Last 10 years in particular, the financial sector has become more robust. And IBC has had a great contribution in that. But I personally feel that some of the decisions of the past delivered by the Supreme Court need a bit of a relook. And one of those judgments is Madras High Court Bar Association judgment on the tribunalization of justice, where the Honorable Supreme Court held that you need to provide safeguards where tribunals are being formed so that the executive doesn't usurp the powers of the fair enough. And therefore, they sort of recommended various safeguards in terms of how the appointments should be made to the tribunals and how they should be manned by retired members of judiciary, in some cases retired judges from the Supreme Court and some from the High Court. And also they said that certain positions like technical members can be manned by people from within the government, whether retired or sitting, and even from the market, but with certain experience. But our institutions in the last 18 to 20 years, particularly some of the tribunals which man economic laws like National Company Law Tribunal, we need a very different approach to appointment to these tribunals. And you have to appreciate, the National Company Law Tribunal is not a creature of IBC. That was created under the Companies Act to resolve the company law disputes. What was created under the IBC was adjudicating authority. At that point in time in 2016, the government in its own wisdom, and I think rightly so, decided that we shouldn't really be creating a new institution as an adjudicating authority, because if it gets challenged in the court, the IBC would be a non-starter.
Right.
They wanted to sort of hit the IBC should hit the ground very soon. And you know how, with the kind of speed with which it was enacted. And therefore it was decided that since National Company Law Tribunal has already gone through a challenge over 8 to 10 years, and its constitutional virus now has been upheld to the satisfaction of the Supreme Court, why do we just give the power of the adjudicating authority to the National Company Law Tribunal? But the National Company Law Tribunal itself was a creature of the thinking of 1990s. It was a recommendation of Iradi Committee set up in 1999 to solve the problem of 1990s. It was never really intended to sort of deliver the IBC, which is a very sophisticated, complex law, and therefore even the appointment process to this NCLT was designed keeping in mind the economy of 1990, the vision of 1990. And I seriously think that the time has come for us to revisit the Madras High Court Bar Association and make room for appointment to tribunals like adjudicating authority.
Sure.
From a very different perspective. You need to have market expertise there, and not necessarily the judges retired from the High Court or even retired bureaucrats. But at the appellate tribunal, yes, the National Company Law Appellate Tribunal, because there you would normally go for the to determine the questions of law. You need retired High Court judges to make sure that they have complete understanding of the principles of law. But the adjudicating authority, we can actually do without them. So these are some of the judgments which perhaps we might need to revisit in times to come to make the effectiveness of adjudicating authority more dynamic.
Absolutely. Wonderful insights. Thank you. Akella, Ahuja, coming back to you now. Let's since we are here and we're talking about how we need to look ahead, how we need to prepare for the future, how we need to have laws and policies that are futuristic in nature so that they don't run behind but actually run with the times or run abreast with the times. So from that perspective, what should we prepare for? How should we prepare? That is one. The second point of my question, of course, is about IP compliance. What is the kind of IP compliance that we have right now? What is the kind of IP compliance that we are heading towards?
So, if you see, in terms of the rules and procedure that we should be going to see into the future, like the IBC 2.0 talks about the cross-border insolvency. This is the first time in Indian law that the cross-border insolvency gives a recognition. So whether recognition is sufficient or whether we get relevant rules and regulations relating to the actual implementation of this cross-border insolvency also, like in terms of how this rules and regulation going to sync with the FEMA Act, with the RBI guidelines. That is the one thing. The another, similarly, like we talked, the IBC 2.0 gives the rooms to the group insolvency. Now, in terms of the group insolvency, is again a very critical topic which requires a details, rules and regulations that we are expecting to come from the IBBI in a times to come. Obviously, once the law is ultimately going to be framed out and implemented. In terms of your second part, which you can you just repeat?
IP compliance.
IP compliance. In terms of the second part, in terms of the IP compliance, IBBI is a new authority, is a new regulator that has been came into the picture upon the commencement of IBC in 2016. Then there are frontline regulator also, which we call it as a insolvency professional agencies. Both are these two parallel institutions to which the compliances are generally being made by the insolvency professionals. Yes, over a period of a time, the compliances has been simplified, no doubt about it, but it still require a major overhaul in terms of digitalizing, in terms of having a single window of the compliances, and more importantly, trusting the insolvency professional, trusting the ecosystem, so that the compliances can be considered to the minimum extent. And more importantly, the role of the insolvency professional is of an investment banker. The IBC requires an investment banking skills with lot of other legal and compliances requirement also. My suggestion that the regulators, the government, the administration, the judiciary expect more of the skill set of the investment banking, and less time should be spent in terms of the compliance, which definitely come once there is going to be deficit, once there is going to be breach into the deficit of the trust that is there in the market.
Right, points taken. So let's work towards more trust, really, as far as the ecosystem and compliance issues are concerned, is what Akhil Ahuja is suggesting. Let's get closing comments now from all the panelists with where do we go from here, what next, and the best way forward, and how do we see IBC, say, a decade from now? Anita ji, let's start with you.
So IBC a decade from now would be stabilized. There would be an IBC 3.0 probably, where the cross-border, the group insolvency, the creditor-initiated insolvency, the pre-pack would have all stabilized, and there would be challenges with respect to climate change. There would be challenges with respect to those kind of costs, which we are already talking in the COP, climate
Summits,
change
yes, climate
committees.
conferences, yes.
Yes, across. It would be, I assume, more. It would be more technology driven. Maybe timelines would be respected over a period of time. Maybe it would be understood that insolvency and bankruptcy code is not a code which requires probably us to look at it in the way that other judicial things are. It's more of a commercial settlement between the creditors and the debtors, and the best man takes it all, because ultimately the company needs to run. But this is about 10 years from now. But I would like to go a bit further. I would like to go to 2047, India and Viksit Bharat, and insolvency in Viksit Bharat, where I envisage that there shall be a kind of a insolvency court mechanism, not a tribunal exactly, because tribunal again has different connotation. Here, I would really look at a bankruptcy court, which is just going to have people settling their matters across the table. It would be more a trust based system, that yes, my company is under stress due to whatever reasons. I come in early. I want to get my creditors on board, and we are coming to a settlement, and this is how we want to do it. Or I am not able to run my company. I want to give it to somebody else. So get me a good buyer, so that we all benefit, and then it moves on. So that kind of a thing, a completely trust-based system is what I would really like insolvency and bankruptcy to be in 2047, and a way quicker mechanism. And honestly, we never thought of what our lives would be with AI 10 years back. So I'm sure AI would be like old hat by then, and we'll have something new to come up. So the all that I can hope is that the processes that we have would stabilize, and the economy would do way better, and we would have more companies into the fore.
Absolutely wonderful way to conclude, really, as far as your closing remarks are concerned. And we hope that all of this happens and all of this comes true. And it looks like it will. In fact, we are well on the path to attain all of these goals. Sumant, Batra, closing comments from you, really, as far as where do we go from here?
Well, I mean, I'd just like to add a few of my wish list items to what Anita mentioned. She's already mentioned quite a few that were already in my wish list. Three things or four things. One, I'm hoping that by 2027, we'll be ready to start or prepare ourselves to implement the individual insolvency law, because that's been sitting on our statute book for quite some time now, and I think it's time for us to start thinking of implementing it. But we'll need about 2 to 3 years of a run-up time for us to sort of give it a deep thought. The second thing which I'm hoping is that we will expand the scope of IBC, and if we want to really make this as a comprehensive code and look beyond corporate institutions and individual insolvency, there are many other sectors in the market which need insolvency treatment. Municipal debt restructuring is one. Bank insolvency is another. And I'm hoping that in another 2-3 years, we'll see that also coming in the radar of the policymakers because of the various developments that are happening. And municipal debt restructuring fits into the vision of Viksit Bharat, something that Anita also alluded on. One of the wish lists that I have, which perhaps we need not even wait for 2-3 years, is to activate the Insolvency and Bankruptcy Fund, which is something provided in the IBC. That is something which came from Irani committee, reiterated by Irani committee. A lot of debate in the parliament, and it was retained also in the IBC bill. The whole idea was that we create this corpus where there's a fund, adequate fund available, which is managed by an administrator, which is made available both to IBBI and NCLT, as also to advance their functions, including in the CIRP. If there is no adequate capital available to run the process, as interim finance, you don't have to go begging. This fund should be able to make this money available on commercial terms. Similarly, for the infrastructure of NCLT, so that you're not dependent. It's like a consolidated fund, a poor man's consolidated fund, if I may say, where you have money contributed from various parties, including by investors for a return. And if we have adequate corpus in this fund, it will help NCLT, IBBI, and other institutions that are delivering various functions of the IBC to be able to do that more efficiently without having to go to the government for approving even small expense from time to time. But of course, you will need a policy on how this money can be raised and spent. But there is a provision already in the IBC for setting up the fund and what the purpose of the fund would be, how the money would be raised, and it's actually quite expansive and allows money to be raised from various sources. And I do hope that some attention will be paid to this in the near future.
Absolutely. And finally, Akhil, Ahuja, close the show for us with your concluding remarks.
So in the IBC 2.0, I'm hoping to see the reduced timeline. The reason for the reduced timeline, the insolvency profession gets an earlier access to the debtor's operations, which helps in the lower erosion on the value of the asset, value maximization, and ultimately higher realization for the creditors. What we are working for, we are definitely working for the creditors, and higher realization will definitely give them boost and give a message to the market, specifically to the credit market, to work out the insolvency as the first resort instead of the last resort. That's the one thing. And Insolvency 2.0 is not only about the insolvency. IBC 2.0 is not only about the insolvency, it's about the confidence to the creditors as well as to the market. And our honorable finance minister has also mentioned a couple of years back that IBC should not lose its sheen. And I'm sure with this IBC 2.0, we can able to demonstrate, we can able to achieve what our honorable finance minister used to say. So these are my closing comments. Thank you.
Okay, all right. On that note, then we'll have to call it a wrap on this edition of Frank Talk. I'd like to thank Anita, Shah, Akella, Sumant, Batra, Akhil, Ahuja. Thank you so much for joining me on the program, sharing your views and putting things into perspective for us. Before we go, don't forget to like, subscribe, hit the bell icon and share the content so that more people get to know about Bharata first. And don't forget to watch episode 1 and episode 2 of our IBC series as well. There's so much of information in there. It's a gold chest, I would say, to try and decipher and understand the IBC as a whole. Until next time, this is Frank Rausan Pereira signing off.